I'm going to ask the parties right now, is there anybody else who needs to be present before we start the hearing? Mr. Pringle?
No, Judge. Staff's witness is here.
Mr. Schulte? I can't hear you. You may still be muted.
I'm sorry. Yes, I was double muted, Judge. Sorry about that. We are waiting for Chris Zadlow to join.
Okay. And will Ms. Cullenbach be joining us?
Yes.
Yes, Judge, I'm on.
Okay.
You're not on video. Are you on video?
Yep.
I see you in here.
Says I'm on video.
There we go.
Coleman. Please leave a message or try me in my office at area code 573-751-4132.
Mr. Agathon, are you waiting on anybody?
Excuse me, Judge, I didn't hear.
Are you waiting on anybody before we start the hearing?
No, we are not. Mr. Lowenstein appears to be present here. He's our only witness.
Okay. Thank you very much. Again, before I ask that if you are not speaking at the time, that you mute yourself.
Mr. Zadlow has joined as well, Judge Clark.
Thank you for letting me know. Okay, it is 9 o'clock. Let's go on
Judge
the
Clark?
record.
Judge Clark?
Yes,
Could you give me just 1 second?
of course. Let me know when you're ready.
Okay.
Commissioner Holzman's here.
Thank you, Commissioner.
Okay, I'm ready, Judge.
Okay, thank you, Ms. Bench. We will go on the record now. Good morning. Today is April 15th of 2021, and the current time is 9:02 a.m. This proceeding is being conducted by telephone and video conference via WebEx. I'm going to ask that you please mute your line unless you are speaking. I'm going to ask as well, there is a chat function that is not part of the official record, and I ask that you not use it. Additionally, there is a hand raise function, and I don't always see that. So if you're wanting to get my attention, probably the best way to do it is to unmute yourself and let me know. Now, the commission has set aside this time for an evidentiary hearing in the matter of the Missouri Landowners Alliance, Eastern Missouri Landowners Alliance, doing business as Show Me Concerned Landowners, and John G. Hobbs versus Greenbelt Express, LLC, and Invenergy Transmission, LLC, as the respondents. And the file number in this case is EC-2021-0059. My name's John Clark. I'm the regulatory law judge presiding over this hearing. Also here today is the commission. The members of the commission are Chairman Ryan Silvey, Commissioner William Kenny, Commissioner Scott Roop, who is present, Commissioner Maida Coleman, who is present, and Commissioner Jason Holzman, who is present. At this time, I'm going to ask that counsel for the parties enter their appearance for the record on behalf of the complainants.
Thank you, Judge. My name is Paul Agathon from Washington, Missouri, and I represent 3 complainants whom you mentioned earlier.
Okay, thank you, Mr. Agathon. On behalf of the respondents.
Good morning, Judge Clark. This is Andrew Schulte at the Polsinelli Law Firm in Kansas City on behalf of the respondents, Invenergy Transmission, LLC, and Greenbelt Express, LLC.
Good
Thank you
morning,
very
Judge.
Go ahead.
And also, Ann Kallenbach, Polsinelli, also on behalf of respondents.
Thank you. And on behalf of the staff of the commission.
Good morning, Judge. Travis Pringle on behalf of staff, Staff Council Department, 200 Madison Street, P.O. Box 360, Jefferson City, Missouri.
Thank you, Mr. Pringle. I'm going to go over some brief preliminary matters. Things are a little bit different since we're doing this by WebEx and video. Obviously, if you've looked at the schedule and have seen post-hearing briefs will not be due tomorrow. I'll address a date for post-hearing dates or post-hearing briefs at the end of the hearing. All witnesses, I'm going to ask that you remain present until you're excused. If anyone needs a break, please let me know. I've received exhibit lists from all the parties. A big one for this hearing is it appears that there may be some confidential testimony and or exhibits. We're going to be doing, because this is being done via video, we're going to be doing in-camera sessions a little bit differently than we might in court. In a courtroom, what we would ask is we would ask that parties that are not authorized to hear the information leave the room. We're going to do the opposite way here. What's going to happen is I'm relying heavily on the parties to let me know if we need to go in camera. And at that time, I'll be doing what's called a breakout session, which means that those people who are authorized to certain information will receive an invitation to join a separate room where the in-camera session will happen. The people that remain behind, I'm just going to warn you that you will want to stay muted because anything you say will in fact be broadcast out over the commission's live feed. Now there's some advantages to that. The advantages are that nobody gets automatically disconnected and that we have a totally private room to discuss. The disadvantages of it are that it takes roughly a minute for everybody to get into the room and start the breakout session. And likewise, when the session is over, it takes about a minute to transfer everybody back to what I'm going to call the main courtroom. So because of that timing, I'm going to ask that we try and go in and out of in camera as little as is necessary. So if there's, it looks like there are possibly exhibits or chunks of testimony that may be in camera, and if we can keep those as chunks rather than going to in camera for a single question, I believe that would be very helpful. Now, the commission may have questions for the attorney and witnesses. I may have questions as well. I'd ask that the commissioners just speak up anytime they have a question. And additionally, if the commission asks, after each party gets an opportunity to question a witness, I will ask the commissioners if they have any questions that they would like to ask at that time. Now, to start out, I'm going to say that the commission is going to take official notice of its report and order on remand in file EA-2016-0358. Are there any objections to the commission taking official notice of its prior report and order? I hear none. Lastly, I'd like to address what happens if people become disconnected, which is a genuine possibility. If you become disconnected, please just rejoin the hearing again the same way you joined it this morning. And if for some reason my internet goes down and I will be disconnected, Jackie Keeley is designated as a co-host, and so the hearing shouldn't shut down, and I will return to the hearing as quickly as possible. Now, at this time, I'm going to address preliminary matters. Do the parties have any preliminary matters or pending motions that need to be addressed at this time? Complainants?
We do not, Your Honor.
Respondents?
Yes, Judge, regarding the confidential sessions, it is our understanding that Mr. Lowenstein has not been designated as a subject matter expert with authorization for confidential information. So we would ask that he not be included in the closed sessions, and I believe that that's agreeable to counsel for the complainant.
Mr. Agathon, you're muted. You said something.
I'm sorry, that is correct.
And that was my understanding as well.
And I would also note that all the excuse me, Judge, if I may, all of the confidential information is respondents' confidential information. In addition to Mr. Zadlow, Nicole Lucky is on the phone. She is VP of Regulatory Affairs for Invenergy Transmission. And if she's allowed to be in the confidential sessions, we'd appreciate that if that can be accommodated.
Okay, thank you. I don't really have a problem with that. Does anybody else?
Is she going to be a witness, or what's the purpose of her being there?
No, she will not testify, just purely to listen.
That's fine.
Okay, thank you, Mr. Agathon. Mr. Schulte, do you have any pending motions?
We do have we made a motion to dismiss earlier in this case on March 12th after the complainants did not file any direct testimony. And we renewed that motion on, I think, in a pleading on March 18th. We do not have, that motion is not pending, I don't believe, in the, because the commission had an opportunity to take it up and did not rule on it. But we may, after the close of the direct case, we may want to renew that motion at the appropriate time, but it's not pending at this moment.
Okay, thank you. And it's my intention to take that with the case. So I will certainly allow you to argue that at the end. Ms. Kallock, anything else from respondents?
No, Judge, thank you.
And finally, any preliminary matters? Excuse me? Finally, any preliminary matters or pending motions from staff counsel?
Judge, just wanted to clarify with you if you're okay with the current numbering of the exhibits. I believe complainants are 1 through 10 and staff is 100. Just want to see if that numbering is okay with you.
That number is fine with me. I don't have a problem with that. Given the low number of exhibits, I don't think that's going to be difficulty.
And then also I wanted to just a reminder that if the commission does request witness Natel Dietrich and Claire Eubanks, they're on the line. They're not witnesses for staff, but if the commission did have questions for them, they are available.
And I believe the other parties were on notice that they could be potential witnesses. Is that correct, Mr. Agathon?
That is correct, Judge.
And Mr. Schulte and Ms. Kallenbach?
Yes, that is correct, Judge.
All right, thank you. At this time, if there's nothing else, we're going to commence with opening statements. And according to the order that was filed by the parties, the complainants will give their opening statement first.
Thank you, Judge. May it please the commission. The evidence in this case shows that respondents have already decided to build a transmission project, which is materially different from the project which you approved in the CCN case. The major changes result from how the power from the line would be distributed among different geographic areas. Under the project you approved in the CCN case, the line was to deliver only 500 megawatts to Missouri, and there was no provision in the CCN case for any to be delivered to the state of Kansas. In contrast,
I'm sorry, Mr. Agathon, you cut out in that sentence.
it made no provision for delivery of any power to customers in Kansas. Is the problem on my end?
I seem to be hearing you fine. I don't believe I lost any of that.
Fine, I'll proceed then. If anyone has any trouble, please let me know. I was talking about the CCN order and how the power was to be delivered under that order. And in contrast, the plan recently unveiled by the respondents would deliver up to 2,500 megawatts to Kansas and Missouri combined. This represents a 5-fold increase to those two states in combination. As a result, that revision will require material changes to the converter station, which was supposed to supply the power to Missouri and will now supply the power to Kansas and Missouri. It will also require material changes to the interconnection originally proposed with MISO. Also, the project you approved in the CCN case was to deliver 3,500 megawatts of power to the PGM states, those along the East Coast and generally east of Illinois. With 2,500 megawatts now going to Missouri and Kansas, that leaves only 1,500 megawatts to be delivered to the PGM system. This represents well under 1/2 of the power which the commission had approved in the CCN order. Again, a change of this magnitude will require material changes to the converter station in Illinois, which was to supply the power to the PGM footprint. It will also require material modifications to the interconnection originally proposed with PGM. Now, the key to this case is that respondents have already committed to making these changes to the original project. We know this because they've told us so. They said so first in a press release this past August. Respondents expressly stated there that they plan to increase the project's delivered capacity to Kansas and Missouri up to 2,500 megawatts. In issuing that press release, respondents clearly convinced top state officials in Kansas that they were committed to making this change. Then, in a letter to landowners just 4 months ago, Respondents specifically stated that, quote, Greenbelt Express has announced a proposed plan to increase the project's delivered capacity for Kansas and Missouri consumers, end quote. They then went on to describe the same plan referred to in their press release. As Greenbelt's letter to the landowners further confirmed, this new plan requires expanding the converter station in northeast Missouri beyond the capacity originally approved by the commission. So the original plan for the converter station is now history. Respondents couldn't have been clearer on that point. Also, in an answer to a data request from complainants, respondents confirmed that they plan to seek regulatory approval from the commission for the changes which they had described in their press release. This can only mean that the plan described in the press release involves material changes to the project approved by the commission in the CCN case. After the position statements were filed, respondents submitted a supplemental answer to that data request I just referred to. In it, they essentially claim that the changes announced in the press release are merely quote unquote contemplated changes. I expect you will hear something along those same lines from respondents' witness today, Mr. Zadlow. But that explanation that they're merely contemplated changes misses the point. Respondents have unequivocally announced that they intend to make major changes to the project which you approved in the CCN case. Now, the details of that new plan may still be in the contemplated stage. But as we sit here today, taking respondents at their word, we know that the final project will include the material revisions which they have already announced and committed to. First question on the joint list of issues is whether the project's design and engineering is materially different from that approved by the commission in the CCN case. Given the major changes already announced by the respondents and how those changes will affect the design and engineering of the project, the answer to the first question is definitely yes. Our answer to the second question involves a successive series of propositions. First, if the commission agrees with us, as I just discussed, that respondents have already committed to building something materially different from the project approved in the CCN case, then complainants submit that respondents have voluntarily abandoned the original project as approved by the commission. I can't still be planning to build the project you approved in the CCN case if they've already committed to building something else instead. Second, once the original project was overhauled, complainants submit that respondents voluntarily forfeited the CCN for this project, which you had issued some 2 years ago now. A CCN for a project that will never be built in accordance with the terms of the CCN is logically nothing more than a hollow nullity. Next, if the initial CCN had been voluntarily forfeited, then at the present time, Greenbelt has no authority to build anything in the state of Missouri. Accordingly, it has no power of eminent domain to take landowner property by condemnation. Finally, respondents continue to tell Missouri landowners on their website that they do have the power of eminent domain in this state. Complainants contend that this claim is false and that respondents are therefore violating the commission's order in the CCN case. Unless there are any questions, that's all I have, Judge.
Thank you, Mr. Agathon. Any questions from the commissioners? I hear none. I do have a few questions for you, Mr. Agathon. Given that it seems to be part of the topic of this case, I'm sorry, was somebody else? Given that seems to be part of the main topic of the case, I'm going to ask you, Mr. Agathan, what would you consider to be a material change in design and engineering?
I would take that in the normal dictionary sense, Judge. I don't think that material is a technical term in the engineering sense. So there was no further expansion on the definition of that term in the CCN order. And so I would say that it's to be taken in the normal dictionary sense.
Okay, when you say the normal dictionary sense, I think there are two, and I just want to clarify that there's material as in bricks and mortar, steel, actual nouns, things, and there's material as in significantly different. Which sense do you mean it in?
Well, in this case, it would certainly include both. So I don't think it would matter. There's going to be material changes to the converter station, certainly in Missouri. And that's going to have a material impact on the design and engineering of the project. And that's just one example. Converter station in Illinois, same situation would apply. So I agree there are probably two different definitions of that term, if you would, but I don't think it matters which you use in this case.
Okay, is there a kind of change to the project that you would consider to be not a material change to design engineering?
I don't have any of the details, Judge. The only details I have are those which I've mentioned and two other changes that they propose to make. They're going to add provision for the installation of high-speed internet, on the line. That was never mentioned in the application in the CCN case, nor was it mentioned anywhere in the commission's order. And second, during the course of the proceedings, Grainbelt specifically stated that they would be using primarily monopole structures. Now they have changed that to using primarily lattice structures, which are much more bulky and take up a larger footprint than the monopole. So those are two other changes that they're making. I'm not aware of details which I would say constitute non-material changes.
Would it make a difference if they decided that they were going to paint all of the poles along the transmission line blue? Would you consider that a material change?
I think some landowners would certainly find that objectionable. I'm just guessing. To them, it might be material. In the overall scheme of things, just the color of paint on the poles, I don't think would fall within either of the definitions that you mentioned earlier.
Okay, you had mentioned that there was some mention on the website of carrying high-speed broadband. Is that correct?
That's correct, Your Honor.
Given that the commission doesn't regulate high-speed broadband except in voice over internet protocol cases involving phone interconnection, why would that be a change that is material from the perspective of the commission?
I would say, Judge, that that was never mentioned in the application filed by Grainbelt originally. That's really what drives the approved project here. There was no mention of that whatsoever. Now they're adding it to the project. That's certainly a change. And I would call it a material change in the design of the project. It was not designed to accommodate high-speed internet originally. Now apparently they're proposing that it will be.
Okay. You had mentioned that this would change the amounts of capacity, I believe, that will be delivered to the PJM system. Is that correct?
That's correct, Judge.
the PJM system is not in Missouri.
That is correct.
So my question is, how is that a material change?
Well, the order of the commission, and in fact, the application from Grainbelt, both specifically mention that they are to deliver 3,500 megawatts of power to the PJM system. And much of the economics was based upon the fact that the prices they could obtain in PJM system were significantly higher than they could obtain in the MySelf system. And that was just one of the justifications, at least mentioned by the commission, in approving the proposal from Grainbelt to build the project. So if that changes, if they're no longer going to deliver the power that justified in part the approval of the project, I would say that's a material change regardless of where that substation happens to be located.
Okay. You indicated that there would have to be a change with the Missouri converter station due to that. Is that correct?
That's correct, Judge.
But to your knowledge, that doesn't change whether or not they're building a Missouri converter station.
I'm not sure they have specifically said what they're going to do, but they have said that they are going to expand beyond the 500 megawatts in the original plan. And they almost have to. I mean, if they're going to deliver up to 2,500 megawatts to Missouri and Kansas, they can't do that with a 500 megawatt converter station in Missouri.
Okay, and I'm asking you these questions because I think you're in the best position to answer them, and I'm not sure that your witness will be able to. And this, if it turns out that the respondents have not actually implemented any of the proposed changes, how is the violation of the commission's report and order granting a CCN?
I would say that's a difficult question, admittedly, but if they have announced and committed to a plan, which they have, which is materially different from the original plan, then they have in fact abandoned the original plan. They're no longer going to build it. They've said so on several occasions. So if they've abandoned the original plan, I think it follows that they forfeited the CCN for that original plan. I don't think you can have a CCN for a project which you've already stated you're not going to build. And once they have forfeited that CCN, then they no longer have the right of eminent domain in Missouri. And they are now claiming still to have the right of eminent domain. So the violation would occur in the fact that they are still claiming to have a CCN in Missouri, still claiming that they have the right of eminent domain. They're telling landowners that they have the right of eminent domain, which does have an impact on negotiations for easements.
Okay, along that same line of thinking, assuming, and this makes an assumption, assuming that there's still time for the respondents to come before the commission and file an updated application for the changes, same sort of question. If that's the case, how is this a violation of the commission's report and order?
The fact that they come in and file for approval of the updated project would not itself be a violation. Violation occurs because in the interim between today or several months ago and the time that they come in and file, there's a gap in there where they do not have it in our possession, a gap where they do not have a CCN to build anything in Missouri. They've abandoned the original project. They don't have approval for the new project, and so they don't have a CCN, which is valid.
Okay, thank you, Mr. Agathon. I believe that's all my questions. Are there any commissioner questions at this point? I hear none. So at this time, I'm going to move on to, it is respondents' turn for an opening statement. Respondents?
Thank you, Judge. Good morning, Chairman Sylvie, if he's on the line, and the commissioners. The commission's rules for a complaint state in relevant part that a formal complaint may be made by petition or a complaint in writing setting forth any act or thing done or omitted to be done by any person, corporation, or public utility in violation or claimed to be in violation of any provision of law or any rule or order or decision of the commission. And that's 20 CSR 4240-2.070 subsection 4. The act or thing done in this case is the issuance of a press release on August 25th, 2020, and some language about potential for broadband expansion on the Greenbelt website. That is the only act or thing done claimed by the complainant. The law, rule, order, or decision in this case is a single condition placed on Greenbelt's Certificate of Convenience and Necessity, which reads, if the design and engineering of the project is materially different from how the project is presented in Greenbelt's application, Greenbelt must file an updated application with the commission for further commission review and determination. And that's from the report and order in the CCN case, which was noticed by Judge Clark earlier. Counsel for the complainants has argued a lot about intent. However, intent about future design and engineering of a project is not only speculative and fluid, but it's not germane to the present design and engineering of the project. And the present design and engineering of the project and the final design and engineering of the project will only be determined when the project is constructed. In a complaint case, the complainants always have the burden of proof. Accordingly, in order to meet their burden of proof in this case, the complainants must demonstrate that the press release and the language about broadband establishes that the design and engineering is presently materially different from how the project was presented during the CCN case. In order to meet that burden of proof, the complainants must meet the preponderance of evidence standard, and to meet that standard, they must convince the commission that it is more likely than not that the design and engineering of the project is presently materially different than as presented in the CCN case. And the commission has previously noted that the burden of proof has two parts, the burden of production and the burden of persuasion. The burden of production requires that the complainants introduce enough evidence on the material issue to have that issue decided by the commission. The burden of persuasion is the requirement to meet the more likely than not burden. For an excellent discussion on the burden of proof in the context of a PSC complaint case, I refer you to a 2008 Ameren complaint case number EC-2008-0329, and an order issued by the commission on December 11th, 2008. The complainants in this case have failed to meet the first part of its obligation. They have failed to present any meaningful evidence that the design and engineering is presently different. The only thing that they have presented are arguments from counsel, and arguments from counsel are not evidence. In fact, the complainants have failed to file any direct testimony explaining their case in chief as required by the commission rules and orders, and today is the complainants' last chance to meet their two-part burden of proof. First, they must meet their burden of production by introducing enough evidence on the material issue to have that issue decided by the commission. In an attempt to meet that burden of production, the complainants plan to introduce Mr. Lois Donald Lowenstein as their only witness. However, Mr. Lowenstein is not an engineer. He has never worked for a utility. He has no experience regarding electric transmission, and he has no expertise on the material issue in this case, which is whether the design and engineering is materially different. Mr. Lowenstein also does not have any firsthand knowledge of the facts relevant to this proceeding. Accordingly, my colleague Ann Kallenbach will be requesting to voir dire Mr. Lowenstein at the appropriate time, after which it will be clear that he is not qualified to testify on any matter relevant to this case. Further, because the complainants have failed to present any qualified witness, they will have failed to meet their burden of production, and respondents will at that time renew their motion to dismiss. We ask that the commission keep in mind that the complainants have been engaged in proceedings before this commission since 2014. They have hired counsel that has practiced before this commission for decades. They introduced expert witnesses in the CCN case, including an engineer, and they have raised money for their lobbying efforts at the state capitol. Accordingly, this case is the antithesis of a pro se complaint with a billing dispute. If the complainants in this proceeding believed that they had a legitimate case based on evidence, they could have and would have presented it. They have failed to do so, and so the case must be dismissed. I'd be happy to answer any commissioner questions.
Any questions from the commission? Okay, I have a couple of questions for you, Mr. Schulte, or maybe just one, depending on how it's answered. Similar question for you. What do the respondents consider to be a material change in design and engineering for this project?
Well, the design, I think the design and engineering will only be known 100% once the project is complete. Now, obviously, the respondents would not wait until the project is complete to request a modification to their CCN if they knew in advance that design and engineering was going to be materially different. And we're mindful that we need to do that with enough time for the commission to consider those proposed material changes if, in fact, they decide to pursue those material changes. What is a material change is not clearly defined. There's some, room for interpretation. I mean, we would concede that increasing the converters or moving the location of the converter station, certainly, or significantly changing the route of the line would be a material change in the design and engineering. Increasing the size of the converter station, the report and order only requires that a converter station be constructed that's capable of delivering at least 500 megawatts. So if the converter station size was increased and that was the only change, we may or may not have a material change. If the converter station is moved and the route of the line changes as a result, that's probably a material change. There's some wiggle room in the commission's CCN order about working with the landowners and micrositing the towers. So those types of changes would not be a material change. The change in the converter station in Kansas, if that moved locations in Kansas, then that's probably not a material change on the design and engineering of the project in Missouri. So, but there's certainly room for interpretation, but the respondents are certainly mindful and if they do have material changes, will certainly be before the commission to request authority to do so.
Is the condition that Greenbelt receive approval from Illinois before beginning construction? Is that a material change to an engineering?
The requirement, there is a requirement to finance the full line. I'm not aware of a requirement to obtain approval from the Illinois Commission before beginning construction, but if phasing was to occur so that the Missouri and Kansas portion of the line was built before the Illinois and Indiana portion of the line, then we would likely consider that a material change and be before the commission.
Okay, thank you. I have no further questions. If there are no questions for the commission, I'm going to move on to staff. And staff, please present your opening.
Thank you, Judge. May it please the commission. On September 2nd, 2020, MLA filed a formal complaint against Grainbelt in which it alleged that Grainbelt is purportedly making changes to its original transmission project, a project approved by this commission in EA 2016-0358. The commission attached a variety of conditions to its order approving the project, including Condition 6, which detailed the materially different from the project presented. MLA alleges that this condition was violated via press release issued by Grainbelt on August 25th, 2020. MLA highlights that, within the press release, Grainbelt announced that it was contemplating changes to the project, which included an increase in the project's delivery capacity to Kansas and Missouri up to 2,500 megawatts of the line's 4,000 megawatt capacity, as well as Grainbelt's intention to begin construction of the Missouri portion of the line before obtaining approval from the Illinois Commerce Commission. MLA alleges that the publication of these and other contemplated changes are evidence that Grainbelt no longer plans to build the project for which the commission granted Grainbelt a CCN, and thus no longer have a valid CCN to build the project in Missouri. There is one thing about Grainbelt's press release that MLA left out of his complaint, and that is the following statement, which I quote, "Building upon the unanimous regulatory approvals from Kansas and Missouri in 2019, Grainbelt Express will seek approvals to the extent necessary for expanded delivery to Kansas and Missouri, as well as for beginning the first phase of project construction prior to Illinois regulatory approval." End quote. This commission is the sole state authority to issue CCNs under Section 393.170 RISMO. Section 393.170.1 prohibits Grainbelt from beginning construction of electric plant without a certificate. From the evidence put forward by MLA, Grainbelt did not begin construction of an unauthorized project when it issued a press release. Moreover, the statute authorizes the commission to impose such condition or conditions as it may deem reasonable and necessary. As acknowledged by Grainbelt, within the very same press release that MLA alleges the violations occurred, Grainbelt will seek the approvals necessary if Grainbelt decides to move forward with the contemplated changes. As long as Grainbelt obtains commission approval of any design or engineering materially different from that already approved, there is no violation of either Section 393.170 or the Commission's condition. And Grainbelt has repeatedly indicated throughout this process that's exactly what it will do. As to the invalidation of Grainbelt's CCN, Section 393.170 is also quite clear on that note. A CCN is invalidated if a utility does not exercise it within 2 years of the effective date of the Commission order granting that CCN. There is no provision in Section 393.170 to revoke a CCN on an uncertain date based on unspecified and subjective evidence of a company's intent to commit to a project. And though MLA has claimed that Grainbelt has abandoned the project approved by this commission, Grainbelt has explicitly denied any intent to abandon its original CCN, and this commission should not stack inferences on top of assumptions to find otherwise. Today, staff witness Sean Lange, who is a professional engineer in staff's engineering analysis department, is here to testify on his experience in monitoring transmission projects for staff and how there has been no evidence presented to signify that Grainbelt has taken action on a project materially different from that approved by the Commission in EA 2016-0358. However, he is strictly a factual witness. He cannot testify as to legal interpretations around Section 393.170. Those arguments have already been put forward in staff's initial and reply briefs filed earlier in October 2020. If you have any questions about the statute and its application in this case, please ask those questions of me. In conclusion, it is staff's position that the mere publication of a press release detailing contemplated changes to the project approved by this commission is not a violation of any commission conditions and does not meet any statutory requirement that would invalidate a CCN. That being said, as the project does move forward, if staff were to discover evidence that the plan has materially changed and that Grainbelt has acted on those material changes without subsequent commission approval, staff would bring its own complaint against Grainbelt. The simple fact today, though, is at this time, there is no evidence of that. Thank you, and I'm happy to take any questions.
Any questions from the commission? Okay, I heard no questions. I'm going to ask similar question, same question. What does staff consider to be a material change in design and engineering?
Lean towards a significant alteration, Judge.
And what would be a significant alteration?
We would say something along the lines if blueprints came up moving the transmission line. Let's say if there was construction on an easement that was not agreed to under a landowner agreement, something along those lines.
Does staff consider any of the proposed changes to be material changes to the design and engineering of the program or project?
For staff, we would need to see more detailed plans than a simple press release and a host of emails, and we have not seen any detailed plans about those proposals. So at this time, we can't conclude either way.
Okay, thank you. I don't have any questions in regard to that. Before we move to having witnesses testify, I'd like to address one thing. Mr. Pringle, you had mentioned the previous briefs that had been submitted in the case. One of the things that was submitted in the case early on that stopped the procedural schedule was a joint motion to suspend the current deadlines and establish a briefing schedule. And contained within that were the joint stipulations of the parties as to certain facts. I'm going to ask, starting with the complainants, are those factual stipulations, do they still hold? Mr. Agathan?
Judge, I have not reviewed those recently. I'd have a hard time answering your question. I assume if we stipulated to a fact, that was, in our mind, a fact at that time. Now, conditions may have changed since that time, which would make what we stipulated to no longer factually correct.
Okay, well, I'm going to go through the factual stipulations then, and you tell me if there are any that you disagree with.
Thank you.
Joint movements have agreed to the following stipulations. Grainbelt issued a press release on August 25th, 2020, which is attached to the complaint as Exhibit 1.
Yes.
Do you agree with that?
Correct.
On September 24th and 25th, Grainbelt mailed a letter to the Missouri landowners who were mailed form easement agreements but had not yet signed them. A copy of this letter is attached to the joint motion as Exhibit A. Do you agree with at least the statements contained in that?
Correct.
Grainbelt has not yet sought commission permission to make the changes to the Grainbelt project as it was approved in the CCN case. The press release states Grainbelt Express will seek approval to the extent necessary for expanded delivery to Kansas and Missouri, as well for beginning the first phase of the project construction prior to Illinois regulatory approval. Do you agree that that factual statement is still correct?
I believe the factual statements are correct.
Grainbelt has not begun acquiring easement rights along the certified route, Grainbelt has begun acquiring easement rights along the certified route, but has not begun construction of the project. Would you agree with that?
I would agree with that, Judge.
The sample landowner letter posted on Grainbelt's website states that Grainbelt is working to add broadband infrastructure along the route to support rural high-speed internet access. And a copy of Grainbelt's sample landowner letter is attached as Exhibit B to this joint motion. Do you agree that the landowner letter says that?
Yes, I do, Judge.
Okay. The other one is in their respective legal briefs. Joint movements may cite to any portion of the record in the CCN case. I've already taken notice of the report and order in that case. I don't really intend to, unless necessary, take notice of the entire CCN case. I think if you want me to take notice of certain portions of that case, that we can address that. And joint movements agree that the issue in this complaint is limited to whether respondents contemplated changes to the project and validate the CCN granted to the Grainbelt. In this case, as has been kind of hashed out earlier, that's not the issues that we're dealing with today. I believe you went through those issues in your opening. So I don't believe those would still apply. Is that correct?
I agree with you.
Okay. A respondent. What I've just said, are there any of those conditions that the respondents do not believe are still valid stipulations of fact for the parties?
Is the question whether they were true at the time or whether they are true as we sit here today?
I think the question for most of them is, are they true as we sit here today?
They are all true with the exception you noted to subsection G, because the issues have been replaced by the joint statement of issues filed at the commission. Subsection D states that Grainbelt has begun acquiring easement rights along the certificated route, but has not begun construction of the project. Grainbelt is continuing to acquire easements along the certificated route, and there has been the beginnings of construction, limited site activity on parcels along the certificated route.
Okay, so that would be true with the addition of some construction?
Yes, Judge.
Thank you. And staff counsel was also a party to this. Are there any of the conditions from the joint stipulation that staff believes are no longer true?
No, Judge, besides the stipulated fact D that Mr. Schulte just addressed. Other than that, everything else still sounds true.
Okay, thank you. I just wanted to get that out of the way first. At this point, if there's no reason not to, I'm going to go ahead and let the parties start calling their witnesses in the order that the parties proposed to the commission. What I am going to say is right now, I've got 3 witnesses down to testify today. Depending on how long these witnesses testify, it's my intent to take a break after each witness, as well as a lunch break. It's about 10 o'clock now, so I expect I will go to about 10:30 before we take a break. Is there anybody who doesn't agree with that? Okay. All right, with that in mind, Mr. Agathon, you can call the complainant's first witness.
Thank you, Judge. Complainants call Mr. Donald Lowenstein.
Mr. Lowenstein, would you please state and spell your name for the record?
My full name is Louis Donald Lowenstein, LOUISDONALD LOWENSTEIN.
Thank you, and would you raise your right hand to be sworn? Mr. Lewis, do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth?
Yes.
Thank you. You may proceed, Mr. Agathon.
Thank you, Judge.
Excuse me, Judge Clark. I'm sorry, this is Kallenbach. May we have leave to voir dire this witness prior to his testimony?
Let me ask a question. What purpose are you voir diring this witness for? Is it merely to establish that they're not an expert?
He's not been designated as an expert, so that was not the direction we were going. He's clearly a fact witness, but we don't believe that he has firsthand knowledge or any perception of the relevant facts of this case, and we'd like to simply inquire about his firsthand knowledge, perception, qualification, skill, et cetera, just to qualify him as a fact witness.
Okay, go ahead.
All right, thank you, Judge. Good morning, Mr. Lowenstein. How are you?
Fine, thank you.
Good. Is it true that you have a bachelor's degree in accounting? Is that correct?
That's correct.
And you are a licensed CPA in the state of Missouri?
Yes,
Okay. So you're not a professional engineer, is that correct?
that's correct.
And you have never worked for a public utility?
No,
Okay. You have no experience regarding the design and engineering of an HVDC transmission line, do you?
no,
Okay. And you have no firsthand knowledge of the specific design and engineering of this particular project, is that correct?
that's correct.
Okay. So, Judge, at this time, we don't believe that this witness is qualified to testify as either an SME or a fact witness. He has no special training or expertise. He has no firsthand knowledge, and we move that he not be permitted to testify in this proceeding.
Mr. Agathon, respond, please.
Yes, Judge. I'll just cut to one question of several that I was going to ask Mr. Lowenstein. There's several questions, and they deal with the publication on the website by Grainbelt of their claim that they have the right of eminent domain in Missouri. And that is,
And has your witness seen that publication?
yes.
Okay, I'm going to overrule respondents, and I'm going to allow this witness to testify.
Thank you, Judge. Mr. Lowenstein, I'm just going to cut to the chase here and get to the factual issue. Are you familiar with Grainbelt's public website?
Yes, sir.
Have you looked at it several times?
Yes,
Have you seen where it makes the claim that Grainbelt has the right of eminent domain in Missouri with respect to the Grainbelt line?
yes, it's on the frequently asked questions page, fourth item in the left column.
When was the last time you noticed that that claim was still on the website?
5 o'clock last night.
Thank you, Judge. That's all I'll have. With this, excuse me, I was going to ask if the witness could be excused, but I know there's potential for cross-examination.
Yes, there is, since we're doing all testimony live and there's no pre-filed testimony. I have down for order of cross for this witness that staff gets first cross-examination.
Thank you, Judge. Staff had no questions.
Any questions from respondents?
Yes, Judge, thank you. We do have several. Typically, I would ask if you remembered your direct testimony, but given that it was 3 minutes ago, I'll assume that we're all still familiar with it. Your counsel asked you about statements on the Grainbelt website regarding eminent domain, correct?
Yes,
You're not an attorney, are you, sir?
no,
So you're simply observing that the statement that we have eminent domain is in its existence on the website, true?
I don't understand your question.
If you're not an attorney, so you're not qualified to testify what that statement on the website might mean or why that might be relevant to this case. You're simply testifying, I believe, and correct me if I'm wrong, that the statement that we have eminent domain appears on the website. Is that your testimony?
That's my testimony in terms of the factual side. I am the president of the Missouri Landowners Alliance, and on behalf of our members, hundreds and hundreds of them, we feel that by putting on the website, you have the power of eminent domain, when in fact, from our position, the validity of that claim is in question. We feel that that puts Grainbelt in a superior negotiation position with our landowners. And we don't think it's fair for them to claim they have the power of eminent domain and use that as a possible strong arm tactic for our members to sign over easements. And that's my deeper assessment of you putting that statement, or Grainbelt putting that statement on their website.
Judge, we'd move to strike the statement that the witness just made regarding a strong arm in negotiations. It's argumentative.
I'm going to overrule that.
Mr. Lowenstein, you're aware, are you not, that when Grainbelt Express received a CCN from the commission, that they were granted the power of eminent domain, correct?
Yes, as long as they follow the provisions of what was granted to them.
And the CCN, it remains in full force and effect until the commission issues an order either revoking it or changing it. Do you agree with that statement?
Judge, I'm going to object. That calls for a legal conclusion. This witness isn't qualified to answer that question.
What's the question again?
The question, sir, was whether he was aware that we have eminent domain based upon the issuance of the order granting the CCN, and that power stays with the company until it's revoked by the commission or the commission issues another order.
It's not calling for a legal conclusion. It's merely asking if he's aware of something. I'm going to allow him to answer to the extent he's able to.
Yes, I'm aware of what you said.
Thank you. We have no further questions.
Okay, are there any questions from the commission? I hear none. I have a couple of questions. I believe I already asked your attorney, but I'm going to ask you directly. You've seen the press release in this?
Yes, sir.
And you've seen the website that the alleged broadband change is in?
Yes, sir.
And you've also seen the letter to the landowners?
Yes, sir.
And did you note those as containing changes from what you knew the project to be?
Well, the broadband is certainly a difference. And in light of the infrastructure plan in Congress right now, I would even question whether a private broadband venture along the line would be superior to providing rural internet everywhere. So I would even question the viability or the feasibility of that statement. Also,
Okay.
things that I read in there talking about not providing as much electricity to the higher priced market out east. I am a certified public accountant. I do understand revenues and expenses, and I can certainly see with clarity that the lower priced sale of electricity around here compared to the East Coast would be significantly different in terms of expected revenue. Hence, is the economic viability of the line the same with that change as it would have been without that change? And I would claim, yes, it's significantly different.
Judge, we'd like to object to the witness's answer. He's not qualified to discuss broadband activity, and regardless of what bills are pending in Congress. we'd request that he stick to the question that was posed, please.
May I comment, dear Judge?
No, wait just a second. I'm going to allow your attorney to respond.
Judge, I think the witness is simply trying as best he could to answer your question.
Well, I believe he's answered the question, and I'll take the rest of it for wait. Do you have any further questions for this witness?
No, we don't.
Okay, any questions for this witness based upon my questions? Staff?
No recross, Judge. Thank you.
Mr. Agathon?
I have nothing, Judge.
And we've already established that respondents do not. It is now 10:08. I had indicated it was my intention to take a short break after each witness. I think this probably is a good time to take a break.
Judge?
So I'm gonna, how long do people need? Is 15 minutes long enough? Okay.
Judge,
put it about-
quick question, if I might, this is Paul Agathon. Could the witness be
Yes.
excused?
I'm sorry.
Let me ask the other parties. I generally prefer witnesses to stick around, but this witness's testimony was extraordinarily limited. Is there any reason that respondents believe they would need to question this witness again?
Judge, I don't know that we believe that we will need to question him, but I'm assuming that because he was asked to be excused, that this is the conclusion of complainant's case in chief. Is that correct?
I haven't asked that question yet.
Well, I believe it is if the witness is intending to leave. At this time, we'd like to renew our motion to dismiss due to the fact that complainants have failed to meet their burden of proof. They've not entered any evidence into the record as part of their case in chief, and the commission has previously found that proof means evidence entered into the record. Even though we did have a motion pending at an earlier time to dismiss this case, we feel that to preserve that, we would like to renew that motion now because they failed to meet their burden. And at this time, we don't believe that we're required to present any evidence to rebut what they have provided. Mr. Zadlow is available to testify on the material issue in this case, but we're not certain that he should be required to do so given the lack of a case in chief that's been presented.
Well, I think you've jumped the gun here. I had talked about taking merely a break after this witness and whether or not the witness can be excused. I didn't ask Mr. Lowenstein if he's finished presenting his case in chief. So I think that's a little bit premature, but what I will say is I will acknowledge the move to dismiss, the motion to dismiss, and I will take it under advisement.
Thank you, Judge.
Judge,
Okay, at this time,
excuse
Mr.
me,
Agathon,
the complainants will be offering the 10 witnesses, or excuse me, the 10 exhibits that they had pre-filed, but Mr. Lowenstein would not be required in any manner with respect to those exhibits. So I'd like to renew my request that he be excused. He does have a prior commitment for 1 o'clock.
well, it's not 1 o'clock yet. I would like him to stick around just a little bit longer in case he becomes necessary for some reason. What I'm going to do at this time is we're going to go ahead and recess until 10:25, and we'll go off the record now. I'm going to ask the parties I assume everybody's just going to stay connected. And if that's the case, since our broadcast is continuous, I'm going to ask that you mute yourselves. Otherwise, whatever you say may go right out onto the web. Okay, I will see everyone at 10:25. Okay, it is now 10:25. So we'll go back on the record. We had just finished with at least for now, with the testimony of Mr. Donald Lowenstein. At this time, Mr. Agathon, you can either present your next witness or go on with the remainder of your case. I think you're muted.
Excuse me. We do not have another witness. Mr. Lowenstein will be our only witness, but if it's a convenient time to do so, I would like to offer the 10 exhibits that we had pre-filed earlier.
And I think it is a good time to do that. If you want to go ahead and offer your first exhibit.
Thank you, Judge. At this point, plaintiffs offer exhibit number 1, which had been pre-filed earlier.
And exhibit number 1
That's
is
a press release.
of August 25th, 2020. Any objection to admitting complainant's exhibit 1 onto the hearing record?
No objection to exhibit 1.
Staff?
No objection to exhibit 1, Judge.
Okay, exhibit 1 will be admitted onto the hearing record.
At this point, complainants offer exhibit number 2, their pre-filed exhibit number 2, which is a response to complainant's second set of requests for admissions.
Any objection to complainant's exhibit 2? Respondents?
Yes, we object to exhibit number 2 being entered into evidence. There has been no foundation laid or context provided for exhibit 2. Exhibit 1 is the press release, which was the issue of the complaint, and we've stipulated to that, but exhibits actually, and I'll hold my objections for the other exhibits, but it's going to be similar. None of them have any context or foundation laid.
Okay. Now, exhibit 2 is a request for admissions, correct?
That's correct.
Yes, sir. And Mr. Schulte, you signed that request for admissions in regard to those answers?
They were verified by Eric Miller, Vice President of Invenergy Transmission. I signed the certificate of service. And there's also some exhibits. So I'm looking at the right, oh, I'm sorry, I skipped ahead. No, I was on the right one. There are some exhibits.
Yes.
Exhibit A is a letter from Mr. Miller and a rendering of a transmission tower.
Any objections from staff?
Yes, Judge. Staff joins with respondents' objection. There's just no foundation or context behind those exhibits.
Okay, I'm going to overrule that objection and complainant's exhibit the responses to second set of admissions is admitted onto the hearing record.
Thank you, Judge. At this point, the complainants offer exhibit 3, but we would like to limit that offer, if we could, to only question and answer to the data request number 8. which is a part of Exhibit 3.
Give me a second to get there. Any objections to Complainant's Exhibit 3?
Yes, Judge, respondents object to the acceptance of exhibit number 3. Not only is there no foundation or context provided, but there was a supplemental response provided to request number 8.
And when was that supplemental response provided?
April 1st, 2021.
Staff?
Yes, Judge, I object to the extent that the supplemental response should be included in the exhibit to give the full context.
I do agree with you there. I'm going to admit it onto the hearing record. I'm going to overrule the objections. However, if you wish to provide the supplemental response as an exhibit, you can submit that for admission, okay?
Thank you, Judge. Do we do that after
Well,
today or live?
Yeah, I'm not going to make you do it now. What I would like for you to do is, unless you want to do it at some point during the hearing, you can do it after the hearing, and I will allow time for other parties to respond to the exhibit and make their own objections.
Okay, do we file that in EFIS or do we send it via email to the parties? We have, I mean, I have a copy of it here. It's just a matter of, I would move to enter it now. But I just, how do I get a copy to everyone else?
That's the difficulty at this point. Does staff have a copy of the supplemental responses?
Yes, I have the email where the supplemental response was sent.
Okay, Mr. Agathon, do you have those supplemental responses?
We do, Judge.
Mr. Agathon, do you have any objections to admitting those supplemental responses?
As long as it's confined to what they sent to us in the way of the supplemental response, I have no objection.
Staff, do you have any objection to admitting the supplemental responses to those answers?
No, Judge, that would be our preference.
Okay, I don't hear any objections, so why don't we call that, exhibit, how are we going to get this to the court recorder? Give me just a second. If there's no confidential information on that exhibit, I'm going to ask that you file it in EFIS, and I'm going to call it Respondents Exhibit 200, and that'll be admitted onto the hearing record.
There is
Go
no
ahead,
comment.
Mr. Agathon.
Thank you.
The complainants offer Exhibit 4, which is a document provided by Grain Belt Express, and generally states that the power will be generated for the line in western Kansas and the surrounding area, which the surrounding area is ambiguous there, but could certainly be left to include even neighboring states like Oklahoma, which would obviously represent a significant change to the project originally approved by the commission.
Any objections?
We object the Mr. Agathon cannot provide testimony regarding the foundation or context for this exhibit, and so no foundation or context has been provided.
Was this exhibit provided in response to a discovery request?
It was not, Your Honor.
And staff would also object, Judge Clark, the ambiguous nature of this exhibit, we just have no background behind it.
Mr. Agathon, would you respond?
It's a statement made by Greenbelt. They're not denying that. And it makes it ambiguous, I think, as to whether or not there has been a change in plan for the project as originally approved by the commission. If they are importing power now from places other than western Kansas, I think that adds to our argument that there's been a major significant change in the project from what was originally approved.
Okay. I am going to admit it onto the record and give it its due weight. 536-070-10 addresses records or memorandum of an active transaction or occurrence as admissible. So that'll be admitted onto the hearing record.
Judge, this is not, I don't believe this is falls into that category. In fact, I cannot testify this came from Greenbelt because I'm not a witness. Mr. Agathon can't testify that this came from Greenbelt because he's not a witness. I don't know if it's connected to any commercial discussions or not.
And I'll note that, and that'll go to weight. So complainant's exhibit 4 is admitted onto the hearing record.
Thank you, Judge. We'll offer exhibit 5 at this point, which is respondent's supplemental responses to data requests number 1 through 4 and 23. Those simply validate the authenticity of the material in exhibits 6 and 7.
Any objections from respondents?
Yes, we object for lack of foundation.
Now, these were answers you provided, answers and documentation provided in response to a data request?
Actually, this is only the answers. There's no documentation attached. It references the attachments and explains why they're confidential. But the attachments are not included as part of this exhibit, as I understand it.
Okay, but the answers are answers provided by Greenbelt in response to data requests.
That is correct. And we've actually, I'd like to expand upon my objection if I can. We did object to all of these responses as not relevant to the subject matter of this case. That was overruled in a motion, in an order granting in part a motion to compel. So I don't want to waive that, but I do recognize that it was previously overruled in a motion to compel regarding relevance.
Okay, staff?
Yeah, Judge, we would object to relevance. The commission doesn't have jurisdiction over the state of Kansas, and these are communications with the state of Kansas.
Mr. Agathon, response?
I don't think it matters to whom the communication was made. It supports our position that respondents have already committed to changing the project to the extent that they're now going to be providing power to customers in Kansas. And again, this was part of a motion to compel that the
I understand that, Mr. Agathon. And so that's your argument as to why it's relevant.
yes.
Okay. Complainant's Exhibit 5 is admitted onto the hearing record, and the objections will be overruled.
At this point, we'll offer Exhibit 6, which is an email thread beginning at the top with an email from Dina Sattler, S-A-T.
Is this confidential in any way?
No, Judge.
Respondent, is this confidential in any way?
This one is not, Judge.
Go ahead, Mr. Agathon.
It's an email dated August 6th, 2020. It states that the line will originate in Spearville, Kansas, as opposed to the original project, which was proposed to originate in Dodge City. I think we're offering this as simply one more example of the changes which are being proposed from the original project as approved by the commission.
And both of these changes as to the route, I assume, are in Kansas.
That is correct.
And you're offering, you believe this is relevant because it shows other commitments to make changes.
Yes, it does. And the gist of the commission's order in the CCN case was that the wind farms would originate in western Kansas and that they would be centered around Dodge City. Now they're saying Spearville, Kansas. So there is at least potentially a change there from the original project.
So you believe that was part of the commission's order?
Yes.
Any objections from respondents?
Yes, we object to relevance and to relevance because it's discussing the Kansas portion of the project. We also object because there's no foundation laid. The people on these emails are not witnesses in this case. They are discussing, well, the difference between Dodge City and Spearville, and again, this is not testimony, but because Mr. Agathon is attempting to provide testimony to give these exhibits context and foundation, if I may be allowed to respond, Spearville and Dodge City are a few miles apart. You can refer to the area as Spearville. But again, there's no foundation, and if we had a witness that could actually speak to these issues instead of making arguments, then we might be able to demonstrate that this is meaningless.
Staff?
Yes, Judge. We'd also object to any to lack of foundation and further the relevance. This has to do with the Kansas portion of the line, and the commission does not have jurisdiction over the state of Kansas.
Mr. Agathon, how does this relate to Exhibit 5? You had mentioned when we talked about Exhibit 5 that it involved the following documents.
That's correct, Judge. It's my understanding, looking at Exhibit 6 here, is that that was part of the material provided to us when the commission overruled Greenbelt's motion to compel. Excuse me. We had filed a motion to compel, they objected, and the commission directed them to file these responses, which included Exhibit 6.
Okay, the objections from respondent and staff are overruled, and Exhibit 7 is admitted onto the hearing record.
Was that 6, Your Honor?
Is that 6? I'm sorry. Oh, yes, that was 6. I apologize. Exhibit 6 is admitted onto the hearing record. Exhibit 7 has not been admitted onto the hearing record.
We are not going to offer Exhibit 7, Judge.
Okay,
Exhibits 8, 9, and 10 deal with confidential material. If there are going to be objections, it's probably going to require that we go into a closed session. I'll make the offer of Exhibits 8C, 9C, and 10C. And maybe there will not be any objections. I don't know.
any objections from respondents or staff to complainant's exhibits 8C, 9C, and 10C, all designated confidential?
Yes, respondents object for lack of relevance and lack of foundation.
Okay, what I'm going to do is we're going to go in camera for this session, and I'm going to create a breakout session. You'll all receive an invitation to join. You may have to click join. It may just take you there automatically. It'll take about a minute to get everybody there, and then we will be separate from what is going out on the live stream. Those people like Mr. Lowenstein who are not authorized to hear the information will be left in the main courtroom, so to speak. Anybody who does remain in the main courtroom, I'm going to ask that you mute yourselves because the live feed will continue to broadcast what's going on in the main room. So anything you say could potentially be heard. And let's see.
Judge, could I say something?
Who's speaking?
Yeah, I'd like to correct something that I stated earlier. We're not going to offer Exhibit 9C.
Okay, I'll mark 9C as not being offered. It'll take me just a minute to include everybody who is authorized to see this information. Staff, is there any reason that Claire Eubanks is not authorized?
No, Judge. All of the staff witnesses are authorized.
Okay. A specific request was made that Ms. Lucky be allowed in, and that was granted. So in actuality, the only person I have who is not authorized to see this information is Mr. Lowenstein. Is that correct?
It is from a complainant standpoint, Judge.
From respondents?
Yes. My understanding is that everyone else on the line is with staff or the commission.
Yes, I believe so.
Okay.
Bear with me just a moment. Okay, and bear with me. I seem to be having some difficulty getting everybody there. Try one more time. Okay, we are no longer in camera. We are on the record in the main courtroom, so to speak. At this time, Mr. Agathon, do you have any other evidence or testimony that you wish to offer in your case in chief? You're muted.
We do not, Judge.
Okay. All right, at this time, respondents, you may call your first witness.
Judge, could I renew my request at this point that Mr. Lowenstein be excused?
I apologize, I forgot about that. Is there any objection to excusing Mr. Lowenstein at this time? Is there anybody who believes that he will need to be called again? Respondents?
No objection.
Staff?
No objection, Judge.
Okay, Mr. Lowenstein is excused.
Thank you, Judge.
Thank you.
Okay, respondents, you can go ahead and call your first witness.
Before we do so, now that the case in chief of complainants has officially closed, we'd like to renew our motion to dismiss. The evidence, exhibits with no context or explanation or foundation do not form the basis of an act or omission by the complainants that violates a rule or ordinance of the commission. And so we would move to dismiss based on lack of a case established by the complainant.
Response, Mr. Agathon?
Yes, Judge. I think the evidence shows that respondents clearly have abandoned the project or will not be pursuing the project, which was given approval by the commission. For example, they're changing dramatically the converter station in Missouri, moving from 500 megawatts to 2,500 megawatts. Since they've abandoned the original project approved by the commission, it's our position that they also have forfeited by doing so the CCN which was granted. That the CCN then becomes a nullity in effect. But at this point, we would argue that respondents do not have a CCN to build anything in Missouri. Therefore, their continued insistence that they do have the right of eminent domain and their insistence in effect that they do have a valid CCN are both violations of the commission order.
Okay, thank you. I'm going to take the motion to dismiss under advisement, and it will be ruled on with the case. Go ahead with your evidence.
Thank you, Judge. In that case, respondents call Chris Zadlow.
Mr. Zadlow, would you please state and spell your name for the record?
My name is Chris Zadlow, spelled K-R-I-S. Last name Zadlow, Z-A-D-L-O.
Mr. Zadlow, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give in this hearing is the truth?
Yes.
Go ahead.
Good morning, Mr. Zadlow. Please state your name and business address. We've covered your name, so your business address and your title will do.
Sure. I'm Vice President of Invenergy Transmission, LLC. My business address is 1 South Wacker Suite, 1900, Chicago, Illinois, 60606.
Could you please discuss your educational background and work experience?
I received a master's in science and electrical engineering from Purdue University in 1990 and a bachelor's of science from Rose-Hulman Institute of Technology in 1989. I am a licensed professional engineer in the state of Illinois. I have been employed with Invenergy since 2008, and I'm responsible for managing services provided to all Invenergy projects with respect to their commercial activities pertaining to transmission assets. These responsibilities include managing technical and regulatory issues.
Is it fair to say, Mr. Zadlow, that you have responsibility for the design and engineering of the Grain-Belt Express transmission project?
Yes, that's a fair statement.
Say that again, please.
Yes, that's a fair statement.
I'm sorry, the question, please.
Oh, I'm sorry.
Is it fair to say that Mr. Zadlow has responsibility for the design and engineering of the Grain-Belt Express transmission project?
Thank you. Go ahead.
Yes, it's a fair statement.
Have you previously testified before the Missouri Public Service Commission?
Yes, I have previously testified before this commission in Grain-Belt's CCN case, as well as the case addressing Invenergy transmission acquisition of Grain-Belt Express LLC.
Thank you. This complaint is based on the premise that an August 25th, 2020 press release indicates that the design and engineering of the project is materially different than the design and engineering described in the CCN case. So has the design and engineering of the project changed?
Absolutely not. The press release was a marketing exercise to indicate our openness to exploring the potential to drop off more power in Missouri. The press release also announced the results of a conceptual study by PA Consulting regarding the opportunity to achieve additional consumer savings based upon various assumptions. These assumptions were part of a theoretical analysis. Design and engineering is not theoretical. Design and engineering of the Grain-Belt Express project is extremely complex endeavor and does not change overnight. We have not stopped and are continuing to pursue the certificated version of the project. That design and engineering is still very much in place.
Thank you, Mr. Zadlow. I have no further questions for the witness.
Okay, I have staff as the next to have cross of Mr. Zadlow. Is that correct?
That is correct, Judge. Staff has no questions for Mr. Zaslow.
Okay. Mr. Agathon, on behalf of complainants, do you have any questions for Mr. Zadlow?
I do, Judge. Morning, Mr. Sadler.
Good morning.
You mentioned the press release issued by Invenergy on August 25th of last year, correct?
I don't believe I mentioned it.
Well, you were asked about it by counsel.
Yes.
Okay. The first paragraph after the heading of that press release says that the phase construction plan discussed in the press release would double investment in Missouri to $1 billion. Do you recall that?
Roughly, yes, I recall that.
Yeah, and could I confirm that Mr. Zadlow has an opportunity to look at the press release itself, if you have it with you, Mr. Zadlow?
I can
That'll be
get it.
fine.
Am I allowed to grab it then?
Certainly, go ahead. It has been admitted into evidence, so you can certainly reference it.
Okay, I have it in front of me.
Okay. Mr. Schulte, did you want those questions that were previously asked re-asked now that he has in front of him, or do you want Mr. Agathon to be able to continue?
I think that would be helpful to re-ask the question. Thank you.
Okay.
Sure.
Mr. Agathan, could you back up and ask Mr. Zadlow the questions that you previously asked in relation to the press release?
Yes. The first paragraph after the heading is blocked out in black. But the first paragraph after the heading says that the phased construction plan discussed in the press release would double investment in Missouri to $1 billion. Is that correct?
So,
Mr. Zadlow, I believe he's asked if that is what it says.
yes, it says it would.
Right.
That's
So
correct.
investment in Missouri would increase by approximately $500 million, correct?
That's correct.
Do you have a copy of the most recent set of data requests which we sent to you? That would have been on April 2nd. It's titled,
Let me ask a question here. Is this an exhibit that's been admitted?
It Has Not.
It was also not on the list of exhibits provided by Mr. Agathon 2 days ago.
Judge, I don't think I'm restricted to asking questions on cross about answers that he gave in data requests, even if they were not admitted in evidence.
I don't think so either. I think you're entitled to ask the questions that you asked in the data request. I don't think you're entitled to use the data requests as a deposition of some kind. So if you want to ask him questions from the data request, you're welcome to do that. If you want to ask him if he remembers what his answer to a particular question was in the data request, you're welcome to do that as well.
Okay, let me start here again. Mr. Zadlow, do you recall stating in answer to a data request to us something to the effect that the added 500 million of investment in Missouri represents the added cost of installing a 2,500 megawatt converter station in Missouri, as opposed to the 500 megawatt converter station included in the plans approved by the commission?
Yes, I recall that.
Could you briefly describe the design and engineering changes which are involved in going from a 500 megawatt converter station to one 5 times that size?
Sure. So we have yet to start engineering and design of the converter stations in Missouri. We have not started that engineering. We have not selected a vendor. What we were stating there were general cost estimates for the difference between a 500 megawatt converter station versus a 2,500 converter station.
Okay, and my question to you is, could you describe the design and engineering changes that would be involved in going from a hypothetical 500 megawatt converter station to one 5 times that size?
Objection calls for speculation. The witness just testified that that engineering has not occurred yet.
Mr. Agathon, what's your question again?
I'm asking him what kind of design and engineering changes would be involved in going from a 500 megawatt converter station to a 2,500 megawatt converter station.
Okay, I think that's very different from asking whether or not design and engineering changes or whether the design is being made. He's asking what would be the requirements to the best of Mr. Zadlow's knowledge for such a change to be implemented. I'm going to allow him to ask the question. Your objection's overruled.
One would be larger than the other.
That's it? It would be larger? There would be no changes in it other than everything would be 5 times the size of what it was before?
Again, I can't comment at what engineering changes would have to occur in the converter station itself. One would be larger than the other.
But some changes would have to occur, would they not?
Obviously, yes.
Okay, thank you. On a different subject, in order to build this line, you're going to need approval from MISO in order to connect your line to their transmission system. Is that correct?
That is correct.
Does that process require that Grainbelt submit some sort of proposed interconnection to MISO for their approval?
That's correct.
Objection. This is
Go ahead and state your objection, Mr. Schulte.
objection. This is outside the scope of Mr. Zadlow's direct testimony. Mr. Zadlow did not testify about interconnections at all.
And I'm just, Mr. Agathon, was your question, do they need MISO approval?
The question is aimed at, let me first back up and address the objection. As I understand it, cross-examination isn't limited to subjects covered in direct examination. Second, what I'm attempting to do is establish that there has been, or could be at least, a change in the interconnection agreement with MISO from the plan originally approved by the commission, that which is going to be required for a 2,500 megawatt converter station.
So is your question if the amount of power delivered changes, does that have the potential to change the interconnection agreement with MISO? Is that your question?
That would certainly be a good part of it, yes.
Is there any other part of it?
And I'm going to go on and ask them if they currently have any interconnection requests pending with MISO.
And how does that relate to the proposed changes in the press release?
It relates to the proposed change in the delivery system to Missouri, going from 500 megawatts to 2,500 megawatts for their converter station. That has a ripple effect, including design and engineering changes in the converter station itself, as well as changes in what's going to be required by MISO in order to approve the interconnection application.
Okay, your arguments are,
Sorry, go ahead.
go ahead.
If I may respond, especially to Mr. Agathon's statement that the examination does not need to be within the scope of direct. Mr. Agathon and the complainant had every opportunity to present an expert witness on interconnections. What's happening here is an attempt to shift the burden of proof from the complainants to the respondents. And so not only is it irrelevant, but it's an improper shift of burden if it's allowed to continue.
As to the first, I disagree with you. I certainly think the complainant is entitled to try and form facts in support of their case off your witness. I also believe that that regardless of whether or not he had the opportunity to call an expert, that has nothing to do whether he can be limited on the scope of his cross, as long as he's not going out of the bounds of what would be relevancy. Mr. Agathon, I would like you to make your point quickly.
I will do that, Judge.
In at least in maybe a couple questions, because I can see where you're going. So if you want to kind of take this path down to a couple questions, I'm going to overrule the objections and allow you to ask your questions.
Try and make it quick. Mr. Sadlow, does Greenbelt currently have any application for interconnecting a proposed line with the MISO transmission system?
We have multiple interconnection requests. We have no executed agreements with the Mid-Continent Independent System Operator.
How many requests are multiple?
We have about 5.
Do you know what the request for the capacity of the converter station is in any or all of those?
I
I'd like
can't
to,
recall. Sorry,
okay.
go ahead.
I'd like to interject here if the questions are going to get into further detail about interconnection requests. I believe those qualify as strategies employed or to be employed, or commercial discussions that are ongoing and commercially sensitive, and would ask that any details about those be addressed in a closed session.
Okay,
I'll withdraw that question, Judge.
okay, questions withdrawn.
Do the applications that you presently have pending with MISO, do they specify where the proposed plan is to be approved? In other words, where the interconnection is supposed to be made?
Yes, they do.
Are any or all of those at the same point as the interconnection originally proposed in the plan approved by the commission?
Yes.
How many of
One
them?
is at the location of how the facility was certificated.
And the others are significantly further away,
They're in different places.
but significantly farther from the original plan.
I would disagree. They're all in Missouri.
Can you tell us approximately how far away the other interconnections proposals are from the one that was?
Again, I believe that this gets into, it's sufficiently enough detailed that it gets into commercial discussions that are ongoing and potentially strategies employed.
I agree, I'm going to sustain that objection.
Do you currently have any applications for interconnecting the proposed line with the PJM system?
Yes, we do.
How many?
There's a couple of requests.
And what is the capacity of the converter station in those two proposals?
I can't recall.
Pardon?
I can't recall what those requests are.
Less than 3,500?
Possibly.
You just don't know whether or not, or you don't know the magnitude of the converter station involved in the two applications pending with PJM?
I would have to look those up.
You have an approximation?
Probably a couple of thousand. But
Right.
those interconnection requests could be submitted at any time.
I understand. But the pending proposals are approximately for 2,000. Is that correct?
Do we need to?
Subject to check.
And I'll ask the witness if more detail would be provided if we need to go into closed session. You know, feel free to let us know, Mr. Zadlow, since you know the answers better than I do.
Well, out of an abundance of caution for this, why don't we go ahead and go into an in-camera session?
Judge, I'm satisfied with the answer that I got earlier. From my standpoint, there's no need to go to a closed session.
Respondent, do you still want to go to a closed session?
No, thank you, Judge.
Go ahead, Mr. Edgerton.
When approximately did you file your latest interconnection application with PJM?
Okay, I think we do need to go into closed session.
Okay. We're going to go in camera again. Hopefully I can do this a little faster than I did last time. As I said before, those people who are left, well, actually, hold on just a second. Okay, yeah, we will need to do a breakout session. Okay, we are out of the in-camera session and back in the main courtroom, so to speak, and back on the record. Well, on the record for that. Mr. Agathon, you had indicated that you had no further questions for this witness. You're muted, I believe.
That's correct, Judge.
Do any other parties have any follow-up for this witness?
After any bench or commission questions, staff will have a few questions.
Okay, thank you, Mr. Pringle. Any commission questions? I know I asked that in camera, but since we're back in the main, I'm going to ask it again.
No
I don't
questions,
hear
Judge.
any. Thank you, Commissioner Holzman. I appreciate that. I want to ask first some information about the press release, answer to the best of your ability. How was the press release done? I mean, how was it circulated? And I believe you're muted, Mr. Zoldo.
I apologize.
Zadlow.
Zadlow, it's okay. When you say circulated, do you mean internally within the company or externally?
I mean, was it distributed via email? Was it sent out in a mailer? Was it both? I mean,
I believe it was both. I think it was put on our website and circulated externally.
now you had described the press release as a marketing exercise. And I'm not sure I understand how a press release indicating you're going to make potential changes is a marketing exercise. Can you explain that to me?
Sure. So what we did was we hired PA Consulting, which was they're an energy consulting firm to perform market studies, right? We hired them back in December of 29 to analyze the market impacts of increasing the converter station and drop off in Missouri from the 500 megawatts. We wanted to understand whether there would be consumer benefits of going beyond the 500 megawatts. And they performed a series of studies. After multiple studies, we became convinced that there were potential large economic benefits to the state of Missouri if that converter station were to be increased. So the point of the press release was to announce those consumer benefits publicly and announce an openness by Grainbelt to increase the converter station and drop off in Missouri. That's the context, Your Honor.
And you don't believe that that is in any way a commitment to make those changes?
That's correct. We have not made that commitment to make that change. Are we exploring it? Absolutely. We have not made that commitment.
What would you consider to be a material change in design and engineering for this project?
Obviously, Your Honor, if we were going to increase the size, if we were going to change the route, those would be material, and we would come back to the commission and seek that approval. As I stated before, we haven't even started the engineering and design of the converter stations. Right now, we're about 30% done with our engineering and design, and that engineering and design is solely focused on the transmission route right now.
And I believe this was covered, but I'm going to go ahead and ask it again anyway, if it hasn't been. So none of the proposed changes in the press release have been implemented in any way?
That's correct.
Okay, I don't have any further questions at this time. Mr. Pringle, you indicated you might have some follow-up based upon commission questions.
Yes, Judge. Well, I think it's still morning. Good morning, Mr. Zadlow.
Morning.
And just briefly on interconnection agreements, are you aware of any requirement the company has with supplying staff with those studies and interconnection agreements?
Unfortunately, I'm not aware of any. That doesn't mean they don't exist. I'm not aware.
All right. Thank you, Mrs. Adler. Would it surprise you if staff is to be updated on those studies?
My understanding is we have to supply annual reports to Missouri staff.
Thank you, Mrs. Adler. And as far as your knowledge, has the company failed to provide any of those reports?
Not to my knowledge.
And then back to the press release, Mr. Zadlow, is it fair to say from your answers earlier that the company has no intent to abandon the approved CCN?
That is correct. We are not abandoning the current CCN.
And I think you did say this earlier, but the press release was more of contemplated or proposed changes, not actual changes.
That's correct.
And also, what does the press release state concerning any necessary approvals if the company were to pursue these changes?
I believe the press release says that if additional approvals are necessary, we would go back to the commission and seek them.
Is that still the company's intent?
Yes, sir.
Yes, sir. Thank you, Mr. Zadlow. I have nothing further, Judge.
Mr. Agathon, do you have any follow-up based upon my questions?
I do not, Judge.
And finally, respondents, do you have any follow-up based upon my questions?
Yeah, one or two, Judge. Mr. Zadlow, just to clarify, you said that the current design and engineering efforts are focused on the transmission route. Is that the certificated transmission route?
Yes, it's only on the certificated transmission route.
Okay. No further questions.
Okay. Mr. Zadlow, did this end your testimony with Mr. Zadlow? Is that correct? Respondent? Is that the end of your testimony with Mr. Zadlow?
Yes, would you mind if I asked, I'm sorry, I should have done it before, but could I ask one more question of Mr. Zadlow?
I think that would be fine.
So the requirement that Mr. Pringle referred to states Grainbelt will provide staff with completed RTO interconnection agreements and any associated studies. Should the studies raise new issues, Grainbelt will provide its plan to address those issues. Has Grainbelt rather completed any interconnection agreement?
No, we have not completed any interconnection agreements with the Midwest ISO.
Thank you.
Okay, can this witness be excused? Staff?
Staff has no further questions. Thank you, Judge.
Mr. Agathon?
I have nothing else for the witness, Judge.
Respondents?
Nothing else, Judge. Thank you.
Okay, I'm going to go ahead and excuse Mr. Zadlow at this time.
Thank you, Your Honor.
Thank you. Okay, this seems as good a time as any to me to take a lunch break. Are there any objections to taking a lunch break at this time? I hear none. Okay, then I'm going to say, why don't we come back at, it's 11:51 now, why don't we come back at 10 to 1? And we will recess until then, and we'll go off the record. Anybody who stays behind, remember, if you yourself, the live stream is still broadcasting, and that means you will most likely be heard by anybody who is watching the live stream Okay, I've got 1250. Can everybody hear? I can't hear anybody yet. Can somebody say something?
Judge, I can hear you.
Okay, thank you.
I can too, Judge.
Just need to be sure that my audio worked and didn't cut out. Okay, why don't we go back on the record now? I believe when we left off, we had just excused Chris Zaldo. At this point, respondents, do you have any other witnesses you want to call or any other parts of your case that you would like to present?
We do not, Judge.
Okay, in that case, staff, you may call your first witness.
Thank you, Judge. Staff calls Sean Lange.
Okay, Mr. Lange, would you state and spell your name for the record?
My name is Sean, S-H-A-W-N, Lange, L-G-E.
Okay, Mr. Lange, would you raise your right hand to be sworn? And there appears to be some lag. Mr. Lange, do you solemnly swear or affirm that the testimony you are about to give at this hearing will be the truth?
Yes.
Okay, Mr. Pringle, you may proceed.
Thank you, Judge. Good afternoon, Mr. Lange.
Good afternoon.
And Mr. Lange, by whom are you employed and in what capacity?
I am a professional engineer with the Engineering Analysis Department of the Industry Analysis Division within the staff of the Missouri Public Service Commission.
And did you cause to be prepared today what has been pre-marked as Staff Exhibit Number 100, the credentials and case history of Sean Lange?
Yes.
Do you have that in front of you?
No, but I can get it up.
Okay, just let me know when you have it.
Okay, I am there.
And at this time, do you have any changes or corrections to make to that exhibit?
No, I do not.
And is it true and correct to the best of your knowledge and belief?
Yes, it is.
Thank you, Mr. Lange. Judge, at this time, staff moves to enter Staff Exhibit 100 into the record.
Any objections from Greenbelt? Sorry, respondents?
No objection.
Any objections from complainants?
No objections.
Okay, staff's Exhibit 100 is admitted onto the hearing record.
Thank you, Judge. Now, Mr. Lange, what is the purpose of your testimony today?
I will briefly address the filing by MLA on March 10th of 2021 and provide an overview of staff's understanding of the current status of the Greenbelt project.
Thank you, Mr. Lange. What did MLA file on March 10th, 2021?
There were 10 files in all, 7 public, 3 confidential, and the information on there appeared to be a press release, information regarding data requests, and emails, internal company emails.
Thank you, Mr. Lange. And have you been able to review all those materials, including the Greenbelt press release, as they became available?
Yes.
And from your review of that materials, were you able to conclude as to whether there were any material changes in violation of the Commission's condition from EA 2016-0358?
At this time, I cannot say that the current project has materially changed.
And in that same Grain Belt press release, was there anything in there about regulatory approval?
Yes.
What did that press release say about regulatory approval?
I recall correctly, it said that to the extent necessary, Grain Belt will come in to the Missouri Commission for any additional approvals.
And beyond the press release submitted by complainants, is staff aware of any other steps Grain Belt may be taking to evaluate possible changes to the project?
Staff is aware of the interconnection queue requests at MISO, at SPP, and at PJM.
And with that other information and the press release, what is staff's conclusion as to MLA's complaint?
Staff cannot conclude that there is material changes to the project.
Thank you, Mr. Lange. I have no further direct questions.
Okay, any questions from complainant?
Thank you, Judge. Good afternoon, Mr. Lange.
Good afternoon.
You've testified on several occasions regarding the Grain Belt project, have you not?
I have.
So you're generally familiar with it and with the commission order approving the original Grain Belt plan?
Yes.
As originally proposed and approved by the commission, the line was to deliver 500 megawatts of power to the converter station in Missouri. Is that correct?
I believe the language says at least 500 megawatts.
Okay.
I
That's the number that was used, though.
I'm sorry.
That's the number that was used in the commission order.
Correct.
And the remaining 3,500 or so was to be delivered to the converter station at the Illinois-Indiana border. Is that correct?
The remainder, yes.
For delivery to the PJM system?
That is my understanding.
Hypothetically, if Invenergy and Grain Belt have now decided to deliver approximately 2,500 megawatts of power to Kansas and Missouri combined, that would represent roughly a 5-fold increase in the total power delivered to Missouri and Kansas. Is that correct?
I believe that's how the math works out on that. Yes.
And if only about 1,500 megawatts is now to be delivered to the Illinois converter station, that would represent approximately a 57% decrease in the power delivered to the PJM systems. Is that correct?
Approximately, yes.
Were you here for the earlier part of the proceeding for opening statements?
Yes.
Did you hear Mr. Pringle state earlier during or near the time of the opening statements that he defined the term material change as one which makes a significant alteration to the initial plan?
I was here for that, yes.
Would you agree that a 5-fold increase in the power delivered to the Missouri converter station would be a significant alteration to the original plan?
If that occurred, yes, depending on the interconnection requests, and it's all interconnected. So
Sure.
a change.
If it goes from 500 to 2,500, That would be a significant alteration to the original plan, would it not?
Everything else being the same. Is that the question? Okay, if everything else is the same, because the language in the order says that at least 500 to be dropped off in Missouri, if there was additional to be dropped off in Missouri, it would comply with that condition. And it would also depend on the original, I guess, documentation, schematics, blueprints, everything else, as to whether or not this additional amount of drop off in Missouri would require sufficient change to the converter station or to the surrounding grid.
And that's my question, I guess. If we go from up to 500, which is 500 max, right? We go from that to 2,500. Would you not agree that that's a significant alteration to the original plans?
I don't know if I could say it's a significant change to the original plan.
Well, how much of an increase would it take in order to be significant?
Well, I would need more detail.
Well, if that's
Because
what we're given, is the change in the capacity of the converter station. All else being equal, if we go from at least 500 megawatts to 2,500 megawatts, is that not a significant change?
a significant change in the amount of drop off, yes.
Okay. And therefore, a significant change to the converter station.
It would require a change to the converter station,
A significant change.
possibly.
Why would it not require a significant change?
Converter stations, while I work on staff and are on the transmission team and work on this, HVDC is still somewhat of new area for myself. I would think it would require a significant change, but I don't know in the engineering of a converter station whether or not it would be a significant change.
Can you think of any circumstances under which it would not be a significant change in engineering and design?
Of the converter station,
Yes.
I think it would require a change. Significant, quite possibly, yes.
Okay. And the same now for the Illinois converter station. If that decreases in capacity from 3,500 megawatts to approximately 1,500 megawatts, that would also be a significant alteration to the original plan, would it not?
Objection, Judge. Relevance, talking about the Illinois converter station when this is regarding the Missouri project.
Overruled. Let me go ahead and answer.
I'm sorry, could I ask for the question to be repeated?
Sure. Changing the Illinois converter station to a capacity of 3,500 megawatts down to approximately 1,500 megawatts would be a significant change to the original plan, would it not?
It would be a significant change to the amount dropped off in Illinois.
And that's part of the original plan.
That is part of the original plan included the entire project from Kansas to Illinois into the PJM system.
Okay, thank you. I have no more questions.
Okay, respondents?
No questions. Thank you.
Any questions from the commission?
Questions, thank you.
Thank you. Okay, I have a few questions for you, Mr. Lange. Now, Mr. Agathon said you had testified in regard to the Greenbelt case before, is that correct?
That is correct.
And that was that in the CCN case?
Both CCN cases.
Okay, and I was getting to that. So it was both the one that was denied and the one on remand that was granted. You testified in both of those.
Yes.
What was your role in that? Was it also
Generally,
engineer?
I'm sorry.
I'm sorry, go ahead. I don't want to put words in your mouth.
Generally speaking, I looked at interconnection studies. I looked at, I guess, health-related concerns regarding the project. I looked at if there were landowners that had questions or concerns on the, I guess, the engineering of electricity. I tried to accommodate that, but those were the main kind of areas that I focused on.
Now, the condition regarding coming back to the commission for approval of any material changes to the design and engineering, that was proposed by staff?
I believe it was.
Now, you just indicated that the current project, in response to a question, you said the current project hasn't changed materially from the design and engineering perspective. Is that correct?
Correct.
When you said the current project, was that just the project as it stands or inclusive of the proposed changes in the press release?
I was attempting to say that the project as defined in EA 2016-0358 has not materially changed, or staff has not found anything to determine it has materially changed in construction or going forward.
So let me ask it another way. So when you say that, when you say based upon the information available, are you looking at the information in the press release? Or are
Yes.
you talking? Okay. And you don't believe that it would constitute a material change to the design or engineering of the project?
If the proposed plan that is outlined or may be outlined in that press release, if that is implemented, then I believe that would have would require material changes. But at this time, I cannot conclude that the plan as defined in the press release has been implemented or is going forward.
And I'm going to stay away from that a little bit. When we're talking about plan, certainly there's a difference between everything that the commission approved and this narrow band that we're talking about regarding material changes to the design and engineering. So I guess my question in regards to that is, when it says that a converter station needs to be built that is capable of handling at least 500 megawatts, is there an upper limit on that?
There would be an upper limit in the design. As
Okay.
far as being defined within EA 2016-0358, I don't believe it is defined anywhere.
How, because staff proposed this condition, did staff have something in mind? I mean, obviously, they must have had something they were concerned about that this condition was proposed. What kind of material changes was staff concerned with?
I think in EA 2016-0358, there were concerns by staff as to whether or not the Missouri converter station would get constructed.
So staff's concern in submitting that it was if that converter station wasn't built, staff would consider that a material alteration to the design and engineering.
Yes.
From an engineering perspective in regard to design and engineering, we've heard the word significant thrown out. How is staff defining a material change?
I can give you my impression of what a material change would be. I think to give you staff's determination of a material change, it would require a larger discussion within staff. As far as myself, a material change may be I guess if you let me use the term, splitting up of the project. If the original project went from Kansas to Indiana, if now we are only looking at a segment from Kansas to Missouri, I think that would be a material change of the project.
What kind of things would you consider, what kind of changes would you consider not to be material changes? Can you provide an example of some of those?
Well, I think within the report and order, there is some leeway given as to how much deviation from the path the line can have. Microsighting instances and things of that sort. Non-material changes, if trying to think of what I could define as a non-material change.
Well, let me ask. I proposed to Mr. Agathan during opening, would painting the towers, transmission towers blue, do you believe that would be a material change to the design and engineering of the project?
As long as they have permissions to do that, I don't know if there's any FAA, anything regarding the color blue or any of that on transmission lines or anything like that. But as long as they have permissions from other bodies, I would not view that as a material change.
And what about the addition of high-speed broadband to a transmission line? Is that a material change in staff's view?
So as I understood the project in the EA case, there was going to be fiber or some way of allowing the ends, the converter stations, to be able to communicate. And so there would be some broadband that would be used for that purpose. Now, if it gets into whether or not having a third party to purchase that capacity, that's getting to an area I don't think I could really talk on without further discussions within staff.
Okay. But just to, again, oh no, that's all the questions I have. Are there any questions based upon my questions, staff?
I guess, should I wait for redirect after the other parties, Judge, or?
That would be fine. Any redirect, Mr. Agathan?
Yes, Judge, thank you. You were asked a couple of questions from Judge Clark about the definition of material change. You recall those?
I do.
Material change is not a scientific or engineering term of art, is it?
No.
So the way you've been using it is just in the ordinary dictionary sense of the term, correct?
Yes.
Thank you. That's all.
Any follow-up questions by a respondent?
No questions, Your Honor. Thank you.
Any follow-up questions by staff? And I'm sorry, Mr. Agathan, I said redirect when I meant to ask questions, but staff, would you like to do redirect?
Yes, Judge. Mr. Lange, you were talking earlier about engineering documentation and blueprints. Do you recall that?
Yes.
For their case, did MLA provide any kind of engineering documents for you to review?
There were some engineering documents in EA 2016-0358.
Oh, I'm regarding this complaint, with the complaint
Oh,
case.
this complaint? No, I'm sorry. No.
Did they provide any kind of blueprints for you to review?
No.
Did they provide any kind of engineering study for you to review?
No.
Without that kind of documentation, can you reasonably conclude that there's a material change to the project?
I cannot, no.
Thank you, Mr. Lange. Nothing further, Judge.
Thank you, Mr. Pringle. Mr. Pringle, does staff have any other witnesses they'd like to call?
Nothing on behalf of staff, but again, if the commission would like to hear from Ms. Dietrich or Ms. Eubanks, they are available, but staff's case is resting.
Okay. Would the commissioners like to hear from Ms. Eubanks or from Ms. Dietrich? I hear no response. I don't need to hear from them at this time. Do you have any other evidence to present?
That is all, Judge.
Okay, so staff rests. All right, let's address kind of closing remarks. I'm going to remind the respondents to file Exhibit 200, the supplemental responses in EFIS as Exhibit 200. Are there any objections to a commission exhibit hold on just a second. Any objections to the joint motion to suspend the current deadlines and establish a briefing schedule containing the joint stipulations? Any objection to that being a commission exhibit for the purposes of joint stipulations A through C and E, but not D, F, and G? Any objections from staff?
No objection, Judge.
Any objections from complainants?
No, Judge.
Any objection from respondents?
No objection.
Okay, Commission Exhibit 1 will be the stipulations contained in that document as to the numbers or the letters that I said would be limited to the letters I said previously. All right, Miss, is there anybody who thinks they're going to be late filed exhibits? I hear no one.
I don't.
Okay, thank you. Ms. Bench, when will transcripts be available?
The actual due date that I was given to the commission was 4/29.
Okay. Now, based upon that due date, are the parties still wanting to do post-hearing briefs? Mr. Agathan?
I think so, Judge. Just one to special briefs.
And I think the commission would probably benefit from briefs as well. So unless anybody has any stringent objections to it, I am going to order briefs on this matter. Now, I believe originally, wasn't there just a single round of briefs proposed?
That's what happened, or that's what the schedule was prior to the current schedule.
Okay, well, let's stick with that. Given that there's an expected transcript date of April 29th, how long would the parties like to file post-hearing briefs? Would the 14th of May be sufficient?
Yes, Judge, that would be sufficient from respondents' perspective. Our perspective, we wouldn't need more than a week, so May 6th would be sufficient for our purposes.
Okay, is there anybody else that would like to move that closer?
May 14th is fine with me, Judge.
I would actually ask Judge if we can push it back a week because I already have a brief due that week.
Okay, so you're asking for the 21st?
We can do that, or even the 18th and the 19th. My other brief due that week is on the 12th, so I'm fine with just waiting until the Wednesday or even the Monday, just someone to give me a little time.
Okay, why don't we do the 18th? Okay, are there any other matters that need to be addressed before we adjourn this hearing? Complainants?
I have nothing, Judge.
Respondents?
Nothing further. Thank you.
Staff of the commission?
Nothing further from staff, Judge. Thank you.
Okay, I'd like to thank everyone for their participation today. I know it's been strenuous at times. And with that, I will adjourn this hearing and we will go off the record.
Thank you, Judge.